Hello and welcome to this contract drafting session, which is being organized by DraftWiz. Whether you are a student or you're a professional, you will always come across contract drafting. Therefore, it is very imperative to understand the basic fundamentals of contract drafting. So, let us proceed with the fundamentals of contract drafting. So, guys, in this current session, I am going to quickly take you through the key fundamentals of contract drafting. I will not deep dive into the legal provisions and mandatory clauses of the contract law, but I will dive you through these relevant provisions or the relevant fundamentals which should be borne in mind while drafting a contract. So, the relevant law in India for contract is Indian Contract Act 1872, which was enforced on 1st of September 1872. So, as per Indian Contract Act, these are key five fundamentals which I have ascertained and which I consider important to be borne in mind while drafting a contract. The foremost thing is the communication, or it is the very first stage of contract drafting, wherein communication of offer is there. So offer can be expressed, or it can be in either in express form or it can be in implied form. The next thing is communication of absolute and unqualified acceptance. Unqualified here basically means which is not containing any conditional acceptance. The acceptance must be absolute. So when there is a communication of absolute and unqualified acceptance, that results into a promise. And the next fundamental is lawful and mutual consideration. Whatever consideration which is there in any contract should be lawful, and there should be a mutual consideration. It cannot be a situation where only consideration, wherein in any agreement there's consideration for only one party. The next key fundamental is lawful object. The object of contract, whichever is being used, or what is the final goal, should be lawful. And last but not the least, the consent should be free. There should be a free consent. A free consent. What is a free consent? That we will deal in the next slides. All contracts are agreements, but all agreements are not contracts. A contract is basically an agreement which is enforceable by law. Therefore, in order to better understand this situation or this particular line, you can go through this diagram which is there. The orange portion signifies those agreements which are not enforceable. Therefore, they are not contracts. Whereas the blue portion, which are enforceable by law and they qualify through all the legal mandates of enforceability, therefore they are valid contracts. So these are the key essentials of a contract. First is enforceability, of course. Next is mutual and lawful consideration. And then comes lawful object. Example, it cannot be a case that you are entering into a contract for purchasing illegal arms. Next is consensus ad idem. It basically means meeting of minds or understanding the same thing in same sense. For example, you approach a person for purchasing Ferrari, but it can be a case that the other person is thinking Ferrari as a horse. So before entering into a valid contract, parties must understand the same thing in same sense. It cannot be a different sense. The next is intention to contract. Parties who are entering into a contract must have intention to act on the agreed terms or agreed proposals. The next is parties must be competent to contract. Lunatic or a minor or the person under intoxication or the person who is not sober cannot enter into a contract. The next is certainty. It cannot be a case that the contract which is there is uncertain. There, of course, there are contingent contracts. Contingent contract basically means those contracts which which depends upon some contingency. But for uncertainty, there cannot be any contract. So the contract must have a clear cut and must have unequivocal terms and conditions. Next comes is it should not be void ab initio or illegal or opposed to public policy. A contract should be should be enforceable by law. Void basically means which is not enforceable. So if you imagine if any activity or an act which is forbidden by law, which is declared as illegal, of course that cannot form a part and parcel of a contract. For example, if there is any act or any decision which is implemented by a government through a public policy, and that particular decision renders a particular activity as opposed to as wrongful or opposed to public interest, then of course that should not be made a part of contract, because that is against the public policy of that particular country where you are executing the contract. And the next comes is acceptance. Acceptance must be unqualified. Unqualified, as I've already explained you earlier, it should be a clear cut, and it should not contain contain conditions that my acceptance will be an acceptance upon such situation only. No, the acceptance must be absolute. It is either yes or it is either no. Either a party accepts the offer or it gives a counter offer. Eventually, the acceptance has to be there, and it has to be an unqualified acceptance. So now we will understand what is a free consent. For a consent to be considered as free, it should these there are five elements should be which should be absent. That is the absence of coercion. Coercion basically means force, and illegal force basically, like you are putting somebody on gun and you are asking to do something. Next is undue influence. Undue influence is basically when a person is at a dominant position and it enters into a contract with a person who is at a dormant position. That is called undue influence. For example, an agreement between a master and servant. Next is absence of fraud. The fraud should not be there, of course, in which you are defrauding somebody's faith. Next is misrepresentation of facts, and the next is a mistake. So there are basically these type of action, or I would say the results of which arises out of presence of these five elements. Suppose if the consent has been obtained out of coercion or undue influence or out of fraud or out of misrepresentation, then will such agreements will be rendered as voidable agreement at the option of such party upon whom coercion, undue influence, fraud, or misrepresentation has been inflicted. Suppose somebody has entered into a contract while forcing me with, like, putting a gun on my head, or suppose if I am servant of master, that is undue influence. Suppose if I have entered into a contract out of fraud, suppose I have entered into a contract out of misrepresentation, then it will be at my option that whether I should continue that contract or I should not continue that contract. So basically, voidable agreements are enforceable at the option of the suffering party. And if suppose the agreement has been entered upon out of mistake, wherein the consent has been obtained as a out of mistake, then such contract or the such agreement will be rendered as void agreement. That will be not enforceable. So let me take you through the general procedure of contract in corporate industry. First of all, there is a meeting in which, suppose there are two parties, party A and party B. Party B requests for a meeting to party A, and during the meeting, next stage comes, that is introduction. B introduces its products and services which it is offering as per the requirements of A. After understanding the products and services from B, A inquires about the pricing. The next comes the offer. B will communicate the pricing in exchange of its products and services to A, that this is the pricing we are offering and will be charging you this much. And the next stage comes is of acceptance, wherein the parties will finally settle the terms of acceptance. Either A will accept the pricing which is being offered by B, or A will communicate a counter offer to B, that, for example, there's a change in figure of pricing in prices. It can be a change in the payment cycle date. It can be a change in the form of payment, or how the payment will be made. So these are small amendments. Suppose if a party communicates the amended pricing or amended offer to other party, the other party will have to signify its acceptance. Either A will confirm the complete acceptance of the pricing which was offered by B, or A will counter offer to which B will have to signify its acceptance. So after settlement of the pricing, these are the next stages in which the parties discuss what will be the scope of work and what will be the commercials. So once the scope of work and commercials are settled, they are decided to be recorded. Of course, to record the terms and conditions, an agreement is an instrument. So drafting of agreement will be the next stage in which all the uh, all the discussions and finally settled terms of scope of work or commercials and everything will be recorded into that agreement. The agreement or a draft agreement will be prepared, and it can be offered, or the draft agreement can be sent by A to B, or the draft agreement can be sent by B to A. The next stage comes of discussion, wherein parties will sit and discuss upon the drafts and negotiate upon the terms and conditions which are there in the agreement. Usually in corporate industry, there are detailed negotiations and discussions which happens, and there are various stages of vetting of contracts. Basically, vetting basically signifies the changes in the terms and conditions, amendments in the terms and conditions which happens during the discussions. It happens mutually. It cannot be a way that both the parties are are stringent in terms of not amending their terms. It cannot be a way. It happens usually that halfway is traveled by A and halfway is traveled by B, and both parties eventually settles all the terms and conditions, which will be final form of accepted terms and conditions. These terms and conditions which are recorded into the agreement will form the final document or final documentation of agreed terms and conditions. All the previous negotiated discussions and offers will stand redundant, and whatever which is there recorded into the agreement will be the final word or the final contract which will be executed between the parties. So this was a small session in which I have taken you through basic fundamentals of contract drafting and what is the procedure of contract drafting. Now, in the upcoming sessions, I will brief you how contracts are drafted, what are the important clauses or provisions which should be borne in mind, and which generally forms a part and parcel of a proper agreement or a contract. Thank you for your patient listening, and let's meet very quickly in the next round of contract drafting. Have a great day.